Okay, good morning. Thank you again for being here for our next installment. I believe this is number 3 on the year. We have Katy Osborn here from Bricker and Eckler this morning to speak about 504s and the implications of that within the school setting. Once again, if you have questions, please use the chat function or the raise your hand function. We have 2 consultants on the back end, Kim Legault and Aaron Curtis from the state support team, that will also be answering questions for you. We ask you please don't send multiple messages to multiple SST consultants during this time. If you just put the general questions in the chat box, or if you want to send, if there's private questions you're unsure about asking, if you just want to send those to me, that way we can just be consistent in our responses to you. That would be the greatest approach to that. There are about 80 participants here, so just so that everybody is aware, we will try to get to every question. If there's questions that we cannot get to or are better served outside of this setting, we will definitely communicate that with you so we can get you the best answer. But thank you to Katy for being here, and Maya, who will be handling some of the logistics on the presenter side, as well as to our sign language interpreters for their hard work today. And I am going to also turn on the live transcript at the bottom, so that way that is available as well. Anybody, if nobody has any questions, Katy, the floor is yours.
Okay, great. Good morning, everyone. Thank you. Thank you for joining me at this really busy time of year. And thank you again for having us here for this series. My name is Katy Osborn, for those of you who I haven't had the pleasure of presenting to before. Hopefully I've seen some of you. I see some familiar names on the participant list. But for those of you who don't know me, I am an education attorney with Bricker and Eckler. I typically work out of our Dayton office, although today I'm in Columbus because this afternoon happens to be our firm holiday gathering. So we're feeling kind of festive around here at Bricker and Eckler today. But I'm here to talk about 504. Just a few housekeeping matters before we begin. As you're probably told at the beginning of all of our presentations, we're not giving you legal advice today. I'm going to give you an overview of the law. If you have a specific question about, a specific thing that's going on in your district, you should consult with your district's legal counsel. And if that does happen to be us, then please feel free to reach out to us after the presentation so that we can have a confidential discussion. That being said, if anyone has general questions as we go, perfectly fine. Please put those in the chat, and I will do my best to try to answer those as time permits. And we'll see. There is a lot of material to cover today. If any of you have heard me speak on 504 today or before today, you probably know that I start talking really fast because there's so much to cover. So I'm going to try to slow it down and give you some good information that you can use going forward. So just to kind of give you the lay of the land today, I'm going to spend the first hour or so going over the nuts and bolts of the law. There's a handout that you all should have had. It's pretty detailed. I'm not going to cover everything in the handout. So that's meant to be a reference or resource for you going forward. But I will go into a fair amount of detail along the way. And then we'll probably take a break at that point. Then for the second hour after that, I'm going to go over the most frequent 504 questions we get in our office. And then at the end, I'm going to read a hypothetical scenario to you about 3 completely fictional students. And we'll go through some questions and answers about those. And hopefully that will you'll know all the answers after I've gone through the whole the rest of the presentation, right? So okay, so let's get started with sources of authority. So the first page in your materials is I'm not going to spend a whole lot of time talking about, but it is a comparison of it's kind of a comparison document between the IDEA and 504. And you probably know the IDEA is far, far more complicated than 504. There are a lot more requirements. It takes a lot more to be in compliance with the IDEA. The regulations for 504 that apply to secondary school, to secondary schools, 4 pages. That's it. It's super short. The IDEA regs, 600 pages. So obviously the compliance issue is pretty obvious just when you're looking at the regulatory scheme. So that first page in your handout gives you kind of an at a glance comparison of the two laws for you to refer back to. So let's start with what the law says. 504 is part of the Rehabilitation Act of 1973. So by its name, you know how old it is, 1973. That's been around almost, but not quite as long as I've been alive. So it's definitely a well-settled law. It's interesting, there are a lot of questions about 504, even though the law hasn't changed in that entire time. And the law it's one sentence. It's just a very basic statement. And since we're going to spend so much time on it this morning, I'm going to read it to you. One thing to keep in mind is that because this law went into effect in the early 70s, the vocabulary is dated. So anytime you see the word handicapped in your materials, please know that it's not because we're insensitive. It's because that is how the law was written at the time, and it hasn't been updated. So, we use other terms today, but the relevant portion of 504 says no other qualified individual with handicaps in the United States shall, solely by reason of his or her handicap, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any program or activity receiving federal financial assistance. So that's the whole thing. That's the basis of the law. We can't deny someone participation in our educational programs or the benefits of our programs, or subject people to discrimination because of their disability. That's what the law says. It's an anti-discrimination law. And the statute is really about access. If you receive federal funds, then you have to make sure that what you're doing is accessible to people with disabilities. And that's going to guide every decision you make under 504. Go back to what is the purpose of this law? What is it for? And it is to prevent discrimination against people with disabilities. Now, I said it's only one sentence and that's it. It's pretty simple, but of course we also have regulations. So the U.S. Department of Education promulgates the regulations, and the regs for 504, like I said, are just a few pages long, just about 4 pages. If you include preschool and post-secondary, we've got a total of 12 pages. So we're not talking about a lot of material. So, you might ask why it's so complicated. Even for a lawyer who likes to talk, it's kind of hard to imagine that I'm going to be able to talk for, 2.5 hours about 4 pages of regs, but there's a whole lot more to it. I'm sure you've all heard of the Americans with Disabilities Act, the ADA. Every time the ADA is amended, there's what we call a conforming amendment. So every change to the ADA also applies to 504. So that's how we've gotten some newer interpretations of the law under 504, even though the 504 law substantively has not actually been changed. And the most recent amendments to the ADA were in 2008. So it's been a little while, but in 2008, Congress made some pretty significant changes to the ADA. And they, of course, then resulted in significant changes to 504. So I'll point those out as we go along today too. But the major thrust of those changes was that Congress in 2008 was telling the courts, you've been interpreting the ADA too narrowly. You've been interpreting who qualifies for protections under the ADA too narrowly. And so the amendments expanded the scope of the ADA, and then accordingly, like I said, the scope of 504. So we also have guidance from OCR, the Office for Civil Rights. That's the office that enforces 504. If you've ever had your district go through a complaint that was filed with OCR, then you may have already had quite a bit of experience with that process. But OCR also periodically issues what we call Dear Colleague letters. Those are letters that provide guidance on how they're interpreting the law, how they intend to enforce the law. And those letters are authority that you need to pay attention to. Some of those letters will come up as we go through the materials today. But it's kind of important to kind of put it into context, what the effect is or the authority level is of those letters. So just to go back to kind of your basic civics lesson, I don't know if we have any history or political science teachers out there, but obviously we all know we have 3 branches of government, right? We've got the We've got the legislative branch that creates the laws. We've got the judicial branch that interprets the laws, and we've got the executive branch that carries out the laws. So the laws themselves come from Congress, comes from the legislature. They're passed by the legislative branch. But sometimes the law itself says right in it that Congress is granting authority to the executive branch, in our case to the Department of Education, to promulgate rules or regulations. And those rules or regulations on how the law is going to be administered, because those come under the direct authority in the law from Congress, those are also law, even though they're promulgated by the executive branch. Now, when those kinds of regulations come out, the Department of Education goes through a rulemaking process when they adopt those kinds of rules. They have to give notice. They have an open public comment period. Then they review those comments, and then they go through all these hoops before the regulations are adopted. So they're vetted. You may recall 2.5 years ago, that's where we were when the Title IX regulations came out. Those were initially proposed by the Department of Education in 2018. And they didn't go into effect until 2020, until August of 2020. And that's because they were going through that whole rulemaking process that they're required to go through. So when we have regulations from the Department of Education for 504, they carry the weight of the law. Dear colleague letters don't go through that process. They're basically a publication by the current administration on how they interpret the law and how they intend to enforce it. But they are the office that's charged with enforcing it. So we still need to pay attention to it, because if you're in compliance with the Dear Colleague letters, then at least the current administration of OCR, you're following that guidance. You're not going to get yourself crosswise with OCR. So we'll talk about some Dear Colleague letters that have been around for a really long time. So those are the basic sources of the legal authority that we're going to talk about today. So on the next slide, identifying a 504, a section 504 student. So where do we start? Well, the very first substantive requirement under the 504 regulations applicable to pre-K through 12, through grade 12, is child find. I'm sure you're familiar with the concept. Now I will say this obligation is not applicable to post-secondary. It is unique to pre-K through 12. The child find obligation, and it's the first obligation under 504, just like it's your obligation under the IDEA. So just like under the IDEA, you've got this child find obligation. Your materials have the reference, the 34 CFR, and then the numbers, the regulation. Just when you see that little code in your materials, just know that that's where you can find the actual substantive regulation in the law, in the rules. So what the regulation says is that you have to undertake to identify and locate every qualified handicapped person residing in your jurisdiction who is not receiving public education, and take appropriate steps to notify handicapped persons and their parents or guardians of your duty under this law. And then you're also charged with conducting an evaluation of any child who, because of handicap, needs or is believed to need special education and related services. So that's your child find obligation under 504. So you'll notice that very closely resembles your obligations with respect to child find under the IDEA. So you're required to conduct an evaluation when you have a student who is believed to need special education and related services. So you meet that obligation the same way you meet it under the IDEA. And just something to know under 504, if you're compliant with the IDEA, you're compliant with 504, right? Because it is so much, you have so many more obligations under the IDEA. But with respect to child find, you do it the same way. You publish a notice, over the summer that says, if anyone knows someone with special needs, please have them contact the Director of Student Services. Notices usually cite to the IDEA and 504, at the same time, because you are satisfying that obligation in the same, in that same communication. So I'm going to spend a significant amount of time today talking about the next slide, the next section, which is what is an individual with a disability under 504? Who qualifies for the protections under 504? Once we determine that they qualify, what does that mean? What kinds of protections are they entitled to, and how do we make sure that they receive those protections? So there are three ways that an individual falls within the protections of the Act. First is the one that I think is the most obvious. It's a person who has a physical or mental impairment that substantially limits a major life activity. And those words, some of them are defined, some of them aren't. We're going to unpack that a little bit and break it down. But physical or mental impairment substantially limits a major life activity. So that's someone with an active disability. And that's what we're going to spend most of our time talking about. But you should be aware that there are other categories of individuals who are also entitled to protections under 504. It protects individuals who have a record of impairment. So what does that mean? So it typically means someone who's no longer disabled. In their records, they have a record of having been impaired. So maybe a preschooler who was identified, but was exited, when they reached school age. That person is still protected from discrimination on the basis of their record of impairment. So we'll get into this a little bit more later. That doesn't necessarily mean they're entitled to 504 programming if they're not currently in need of 504 programming, but it means they can't be discriminated against. The basis of the act goes back to anti-discrimination. So a person with a record of impairment cannot be discriminated against. And then the third category is a person who is regarded as having an impairment. So that could be an impairment that's minor, not a substantial limitation, transitory, an impairment that doesn't substantially limit a major life activity, but that is perceived as a disability. Those individuals, again, they're not going to be identified as individuals with a disability or a current impairment under 504. So they're not going to be entitled to programming, but they're still entitled to those anti-discrimination protections under the act. So just know that the statute requires anti-discrimination protections to people in all three of those categories. So the first question with identification is the impairment a substantial limitation of a major life activity? So we'll talk, we're going to break that down. Let's talk about the first category. So there are really three concepts. So it's mental or physical impairment that substantially limits a major life activity. Before we get too far into what these three things mean, I do want to briefly touch on a person with a temporary disability, like a broken leg or a broken arm. If someone has a broken arm, do they have a substantial impairment or, that would be a physical impairment that substantially limits a major life activity, right? If their arm is broken and they can't write and they can't do the things they need to do for self-care, clearly that's going to be a substantial limitation on a major life activity, probably. But we do have some guidance on this, and it comes from those 2008 ADA amendments that we then apply to 504. Temporary disabilities only count as disabilities for 504 purposes if they are expected to last longer than 6 months. If the expected duration is 6 months or more, then they're going to apply, they're going to qualify for protections. So typically a routine broken arm or broken leg is expected to heal within the 6 months. So that is probably in a typical case not going to qualify as a current impairment. A routine broken arm. Now that doesn't mean that there can't be complications. That doesn't mean that there aren't situations where it would qualify, but just in general. And there is a case in your materials about this, but the takeaway is that if an impairment is expected to last 6 months or less, we don't treat it as a disabling condition. But be watchful, because sometimes you think something's only going to last 6 months and it continues, and that, evolves into a different story. And one area where we're really seeing this come up is with concussions. If you have a student with a concussion, you need to monitor whether that impairment of a major life activity lasts longer than 6 months. Even though it's temporary, it could turn into something that qualifies as a disability if it continues on beyond that 6 month, kind of threshold. And you have an ongoing child find obligation. So if the condition that you thought was temporary continues beyond 6 months, if you've got a student exhibiting a need in the classroom, related to that concussion beyond the 6 months, they have headaches, they have difficulty concentrating, just be aware that that temporary impairment might have just turned into an impairment that qualifies the individual, as a student for protections under 504. So is the impairment a substantial limitation of a major life activity?
Hey, Katie?
Yes.
I'm so sorry to interrupt. We have a question, and it might be an issue, a problem that on our end that I've created, I guess. In the materials that we were provided, there was only a PowerPoint slide. Are you providing for this session the document?
Yeah, there's a detailed outline that should have been sent over to you. Did you all not receive that?
It's possible we did, and I just forgot or I
Well,
just did not put it in. Is it,
it's possible that you didn't. It's a 26-page outline.
okay,
Let me see. I can, Maya, if you can hear me, would you email Kristen Porter and ask her if she sent the outline?
Yes.
Okay, why don't, should we do that?
okay, yeah, that's fine. Sorry, I apologize to all the participants. that,
No, I apologize if you, I
stand
don't
by
know
on
if that
that.
was, I don't know if that was on our end or yours, but yeah, oh, somebody just said they received it.
Okay, yeah, we had, so, in the past, I didn't want to put the old, I have one from 2019, but I figured that had been updated or changed, so I didn't want to put that in, but
Yeah,
yeah, if there's a more updated one, people are saying they received it. So,
okay.
I don't know.
Okay, someone did ask for it to be resent, so would you like us to? Looks
If,
like people have it.
who has, if Kendra says she has it and Joe says they have it, can they just send that to me real quick and I will put it in the folder for all the participants?
Okay. That's
Yeah,
it.
I don't know what happened, so I apologize to all the participants. That's I think what was in there was what we were made aware of, so I don't know where that got. I will double check that next time, but I apologize. We'll get that to you guys as soon as possible. I'll put it into the chat box as well as the participant folder. Sorry for that interruption.
No, that's okay. I hope we can get that resolved quickly so everybody has it. So I'm sorry if that was an issue on our end. I'm not quite sure what happened. So, okay, so let's see, where was I? Substantial limitation of a major life activity. So I'm sure this won't come as a surprise, but the handful of pages of regulations don't give us bright line definitions. So what is a substantial limitation? I have no idea. It depends. There's not really a legal answer. It's going to be a case-by-case basis every single time. So let's walk through an example. If you have a student who presents with a gluten intolerance, the student does not have celiac disease, but just an intolerance. They don't do well when they're consuming, foods that contain gluten. So I think we can all agree that's an impairment, but there are no issues with the child and no limitations in the education setting. So the analysis might be different if the child does have issues in the education setting, if the child is missing instruction, they have routine absences. But in this case, it's not going to be a substantial limitation. So, but just the important thing to remember is that it is always a case-by-case analysis. One person with a gluten intolerance may have a substantial limitation and a different person with a gluten intolerance may not. So there's never going to be a hard and fast rule. You just have to look at the facts, look at how that impairment is manifesting with that individual student, and then make a judgment. But we don't really have any definitions of substantial limitation. Now, we do have a definition, though, of what a major life activity is. And that also comes from those 2008 ADA regulations. And it was an expansion of what major life activity was previously being interpreted to mean. So there is a list in that handout that hopefully you'll all be getting. I believe it's at the top of page 4. But let me give you a little caveat. Anytime you see a list in our handouts, in our materials, it's not going to be exhaustive. It's just, it's intended to be a guideline. No list we ever give you is going to be exhaustive, right? Because there's always a situation that you can't anticipate. So just, you can see though that the list in there is pretty extensive, just about everything you do. Caring for oneself, performing manual tasks, seeing, hearing, eating, sleeping, walking. I mean, those are all major life activities. And if you look in the right-hand column, you'll see some activities that are bolded: learning, reading, concentrating, thinking, and communicating. So those are things that you're doing in your buildings as educators every day. Those are the things our students are doing every day. And those are major life activities under 504. So those were added to the definition in 2008. And this is one of the areas that, that was really expanded in 2008. Other expansions, it now includes the operation of a major bodily function. So that pulls in things like celiac disease, Crohn's disease, cancer, other long-term illnesses, if they substantially limit the major life activity of the operation of a major bodily function. So a substantial limitation has to be evaluated without regard to what we call mitigating measures. So this is another area that was expanded in 2008. And like I said before, I can't give you a definition. Maya, I think you can advance to the next slide. I can tell you though, what you can't do when you're evaluating whether someone, whether something is a substantial limitation, is you can't consider mitigating measures. So you have to consider them in their, what we call their unmitigated state. So what that means is if you've got a student with ADHD, all right, so we've got a student, we know the student has ADHD, but they're taking ADHD medication. And when they're on their medication, they can concentrate. They're not wiggling in their seat. They're not unable to, to attend to their work. And when you evaluate them, if you say they're not substantially limited in their major life activity of concentrating or thinking, you're looking at them in their mitigated state with their medication. In order to determine whether they're an individual with a disability, you have to look at them in their unmitigated state. So what does this student look like without their ADHD medication? So sometimes when we tell clients this, the response we get is, well, I've never seen this child without their medication. So, how would I know what they look like in their unmitigated state? Well, you've got to find somebody who has, a lot of times there are people in the district who, possibly before the child was diagnosed, before the child began taking medication, will remember what they were like in their unmitigated state. The parents can probably give you some information about what this child looks like in their unmitigated state. But the reason for this change under the 2008 amendments was to expand the coverage, to expand the scope of the people, the individuals who are entitled to protection. So there's an ADA case out of the Supreme Court that is that gives you some guidance on how this came about. This is a U.S. Supreme Court case. Now it's an ADA employment case, so this is not a 504 case, but it borrows. It's the same logic. It's from the same the same source of interpretation. So it was about an employee with carpal tunnel syndrome. And this employee was a manufacturing employee. He worked on an assembly line. And he was able to work and do his job and meet the expectations, perform the essential functions of his job when he had a brace on his hand to, to assist with the carpal tunnel condition. And he claimed that he was he was an individual with a disability entitled to protections under the ADA, and that he was being discriminated against because of his disability. And the trial court said, you can do your job. You're not substantially limited. And while that's true, that was only true while he was wearing a brace, which is a mitigating measure. So the Supreme Court said you need to look at him in his unmitigated state. And if he is substantially limited in a major life activity without the brace, he's entitled to the protections against discrimination under the ADA. So that's kind of how we got to this point. So Congress expanded the scope of the ADA as their way of saying that those lower courts got it wrong. This is an anti-discrimination act, and you should be interpreting it very broadly. I think we just lost, did we lose our slides, or was that just on my end?
No, I'm not seeing them either.
Well, I wonder if Maya lost her connection. Are you able to see if Maya's still on?
She is not currently on though.
Okay. Well, I don't have the slides up.
Let me pull them up real quick.
And also real quick, we did get that document was just recently sent. So I know Steve dropped it to where you could download the PDF, but it's also in the online folder as well.
Okay.
So we will have both of those for all of our participants.
Okay. Well, in the interest of time, while we're trying to get the slides back up, I'm going to keep going just because I don't want to run out of time. So, like I said, Congress was trying to expand the scope of the ADA and expand the scope of individuals who are entitled to protection. So you can't consider children in their mitigated state. Here we go. I think we're on, let's see what slide number we're on. Maybe slide 6. Yes, that's where we are. So, okay, are we good? So that's the mitigating measures that you can't consider. There is a list of mitigating measures in your materials. Again, it's not an exhaustive list, but medication, like ADHD medication, hearing aids, use of assistive technology. But what you're going to see often are the last two on your list are reasonable accommodations and learned behavior or adaptive neurological modifications. So I'm going to talk a little bit about that. Shortly after the ADA Amendments Act in 2008, there was a district who had a student who was asking for 504 accommodations, extended time on the ACT. Excuse me. Now, the student was a junior in high school, ranked in the top 10 in his class. He was doing very well. And the district said, you're not an individual with a disability, so we're not giving you a 504 plan. And the family went to OCR because they had a letter from the American Institute of Dyslexia that said that this student had dyslexia, despite the fact that the child was doing very well. And the district's response was, well, yeah, maybe so, but we're not seeing any effects of that in the classroom. And so the child does not need extended time on the ACT. And OCR said, you looked at him in his mitigated state. And their logic was that if this student has dyslexia and has gotten as far as he has, is in the top 10 in his class, doing as well as he's doing, he's probably learned how to do things like how to chunk or how to context clue read. And all of those are the things you would teach him as a student with dyslexia, but those are learned behavior modifications. And that is considered a mitigating measure. So they said, you can't look at him in that mitigated state to determine whether he qualifies. You have to go back and reevaluate him and consider in his unmitigated state whether he has a substantial limitation. So that's a real life example. I'm going to come back to the student a little bit later in the presentation, but that's an example of how mitigating measures factors into this analysis. Another change that we got from the 2008 regulation was some guidance on episodic impairments. They're kind of like temporary impairments, right? Because they're usually brief in duration, but they're recurring. So if something is recurring, it's going to qualify an individual for protection if when it's active, it substantially limits a major life activity. Okay, so just keep that in mind with episodic impairments. You don't have to have something that when it recurs, you don't have to have someone who's having a 6-month-long seizure, right? Obviously. But when they have an episodic impairment like seizures, when it's active, if it is a substantial limitation on a major life activity, that is going to qualify for protection. So on the next slide, the final thing we got from the 2008 regs that I'm going to talk about is alcohol use and drug addiction. So we have information on the use of drugs and alcohol in the public school setting. I'm not going to get into great detail, but there is guidance that exists on this. And the guidance essentially says that people who are in recovery qualify for protections. So individuals who are actively using and are not in active recovery do not have protections under the Act. So just keep that in mind. We also have very clear language that agencies may take disciplinary action for the use of drugs and alcohol, even when the individual is in addiction. All right, so once we've identified on the next slide, the next step is evaluation. How do you determine whether someone, how do you determine whether someone is an individual with a disability? How do you evaluate that person? So anyone can make a referral. That's important to know. It can be a parent, it can be a teacher, the student can self-report. There is an evaluation requirement. You have to evaluate before you do an initial placement. You can't develop a 504 plan without evaluating. That is, that's a baseline requirement. And you can't delay evaluation because of another process like RTI, ELL services. You can't require those processes as a prereq to the 504 evaluation. Once you get a referral, you have to evaluate. So if you get an OCR complaint, and it's a failure to evaluate, failure to identify complaint, the very first thing OCR is going to ask for is a copy of the 504 evaluation. So if you just did a plan and didn't evaluate, you're out of compliance right off the bat. You can't satisfy the requirements. So you've got to make sure that step does not get missed. But a 504 evaluation, the good news is it doesn't look anything like an IDEA evaluation, or at least it doesn't have to. IDEA, of course, has very complicated procedures, but the evaluation under 504 can be as simple as a group of persons knowledgeable about the student sitting down to discuss the information they have. That is the extent of the requirement under 504. So that may require, more work or analysis or data in order to get that group of people who are knowledgeable about the student and to compile the data, but it also may not require that at all. If you've got a diabetic student, you might just need the parent and the nurse, and that's enough to talk about, the child's needs. So it just depends. There's no requirement that you have that properly constituted ETR team the way we have under the IDEA. On the next slide, consent. You do have to have consent. OCR has said that consent is required to conduct an evaluation. It's usually on the form, the parent is consenting to the 504 evaluation, we get their signature. Technically speaking, and I'm reluctant to say this because I would never want you to do it, but there is no requirement that that consent be in writing. But that's a really bad practice, because how do you document that you have consent if it's not in writing? So you want to get it in writing. Now, the evaluation procedures, which I think is on the next slide. When do you evaluate? So starting with the timing, there is nothing in the 504 regs about the specific timing of 504 evaluations. There's nothing that says you have to do a triennial review. However, be aware that your board policies very well may say that they very well may require it. So you need to know your own procedures, but even if it's not a legal requirement, your board may have adopted a policy. And I see it regularly that the board's 504 policy says there's going to be a triennial reeval. You know, I think it's just the mindset of keeping you on track, because you're doing that with your students on IEPs anyway. But the legal requirement under 504 is there are 3 times that you're required to evaluate. 1 is an initial evaluation, of course, as I mentioned. 2 is before a significant change of placement. And 3 is the catch-all, when conditions warrant. So what does that mean? Well, it means what you decide it means. A lot of districts do evaluations when a child is transitioning from one building to the next. Some districts do it every year, some districts do it every 3 years. You decide, but know that, again, while you do need to follow your board policy, it's also still a unique decision. It depends on the child's needs. When the conditions for that individual student warrant a reevaluation, you do a reevaluation. So if you see a change in the way a student is functioning, probably conditions warrant a reevaluation. If you see, additional needs manifesting or being exhibited in the educational setting. But other than that, there is no specific law about the timing of your 504 reevals. So once you've found them and evaluated them, what next? So on the next slide, we're going to create a 504 plan. So you have to have, again, this group of people who are knowledgeable about the student, who are knowledgeable about the meaning of the data they've collected in that evaluation and what the placement options are. That's your ETR team for 504 purposes. So it's not, the gen ed teacher, the special ed teacher, the district representative. I mean, you don't have that same list. You've got to have the people who know the information and can assess the information in order to develop the plan. So you can use a little common sense and logic here, but their role then is to review the data, have a meeting, and make that determination. So you come to the table after the evaluation to decide 2 things. 1, you're deciding whether or not the student qualifies for protections, qualifies as a student with a disability under 504. And if so, whether that student requires the provision of special education and related aids and services to meet their individual needs as adequately as the needs of non-handicapped students are being met. So it's really a 2-part question. There are times when you might find that a student is eligible, but they don't need a plan. That can happen. So it is a two-part analysis. But generally, if the student is eligible, you're probably going to be writing a plan. If they're not eligible, you're not writing a plan. But either way, at this point in the process, parents are entitled to their procedural safeguards. One way or another, you have to tell them, here's what we decided as a team, and here's a copy of your rights under 504. And if you disagree with us, this is how you sue us. So you do have to give them those procedural safeguards at that point in the process, and that is a requirement. One question that we often get is, I know a lot of districts, and many of you may be in districts who use prior written notice forms that look like IEP forms for your 504 students. That is a way to document the decisions that are being made. It is not a requirement. That PRO1 form is an IDEA form. There's nothing in the law under 504 that requires that. And the form has more procedural requirements than you are required to give under 504. It has those 5 sections, what's the action you're taking or refusing to take, why, what else did you consider, that 5-part form. You don't have to do any of that for 504. You have to give them notice of the decision and a copy of the procedural safeguards. We met on this date, we reviewed this is our decision, here are your procedural safeguards, and that's it. So I do think a lot of districts want to use that just for consistency. I personally think using that is confusing to parents. I have had parents think their child is on an IEP because they're getting those kinds of forms when their child is not on an IEP. So I don't recommend it. I don't think my colleagues recommend using that form for 504 students. There's nothing legally wrong with using it. You're just giving them more than they're entitled to. So, but let's talk a little bit about writing the plan on the next slide. There is an LRE requirement. A placement has to be the LRE for the student. And that means the same thing under 504 that it means under IDEA. That's an area of similarity. So to the maximum extent appropriate, these students shall be educated with their non-disabled peers. And this is on the next slide. There is also a FAPE requirement. The child must receive a free appropriate public education. That's defined as the provision of regular or special education and related aids and services that are designed to meet the individual educational needs of a student with disabilities as adequately as the needs of students without disabilities are met. So that should sound familiar to you. Notice it does not say we're giving accommodations. People tend to think that 504 is for accommodations only, and that's not accurate. FAPE for 504 purposes can include special education and related aids and services. If you have a student with a disability under 504, for example, who doesn't meet the specific criteria for eligibility under the IDEA, they don't fall into one of those 11 eligibility categories, but they're nonetheless an individual with a disability. They can have their needs met on a 504, and it can include special education. Looks like we have a question. Is the school district responsible for 504s under child find for non-public? The child find obligation is the same. So if you have a student who lives in your district, you do have a child find obligation under both 504 and under the IDEA for that student. Okay, so let's talk next about the scope of services and accommodations. On the next slide, accommodations, of course, have to be reasonable. You do not have to provide an accommodation that is not reasonable. So the question is, what's a reasonable accommodation? And again, it depends. How far do I have to go? How far do I draw the line? So someone is asking for a clearer example, let's see, of a student who qualifies for 504 and has a special education service. Let me think about that. I mean, I probably don't have a good example. I mean, it's a local decision. If you've got a student who qualifies under 504 and their needs can be met on a 504 plan, it's really a local decision. I think many districts are more inclined to go through the IDEA process and pull funding for that child if they need special education. But I mean, it's not required if their needs can be met with a 504. So how far 504 doesn't provide, you can put special education and SDI on a 504. You can do that. There's nothing that says that you can't. And if you even just Google OCR guidance, it's right in the OCR guidance that you can do that. Like I said, I don't see I'm getting lots of questions popping up all at once. Is the responsibility just to write the 504 for the school or just to evaluate? I'm not quite sure what you mean. Are you asking for a student who doesn't attend your school? My understanding is that you have the child find obligation, but if they're not going to attend your program, then they would have their 504 plan developed by the non-pub. I think that answers your question. Okay, so back to how far you have to go. Where do you draw the line with an alteration? The answer is when you fundamentally alter the program, then that's no longer going to be considered a reasonable accommodation. So for example, how much extended time is too much time and results in a fundamental alteration of the program? So that's something that comes up often with twice exceptional students, right? So let's say you've got a child with ADHD and anxiety, but they're also gifted. And they're in accelerated classes, but the student has a 504 plan that says they only have to complete 75% of the reading or 75% of the work. I don't know if you see this in your districts. We often hear that teachers give some pushback in that situation because they say that that's turning that class into something that is no longer an AP class. So, there is a line somewhere along the way that's going to fundamentally alter the program, but there's no bright line test on whether it's 75% or 90% or 50%. It's going to depend on the class, and it's going to depend on the child and their needs. But the takeaway should be, though, that you can't condition the receipt of services, that AP class. You can't condition taking that AP class on the student forfeiting their accommodations that are on their 504 plan. So you still have to make reasonable accommodations with the reasonable limitations. So if they get to the point where it becomes a fundamental alteration, that case by case basis. If you reduce the work in an AP class to 50%, is there an argument that fundamentally alters that class so much so that it is no longer an AP class? Maybe that might be a fundamental alteration. So there are limitations, but you have to make that decision, based on the accommodation, the facts and circumstances. And like I said, there's just simply no, there's just no bright line test on what is a fundamental alteration. So equal opportunity and access, I think we're a couple slides behind. If you want to advance just a couple slides. There we go. So remember that this is an anti-discrimination statute. Excuse me. So it says we're going to make all of our programming available, accessible. We're not going to discriminate or make any of our programming inaccessible to students with disabilities. And so you can see on the slide, those pictures, this means all of your programming. That includes field trips, and it includes sports programs. And this is something that we see that frequently comes as a surprise to coaches. Not only the obligation, sometimes even if the coach knows there might be an obligation, they aren't informed about the student's disability. So for example, we had a student who had extended time on their 504, and she tried out for cheerleading. She was, went through the tryouts for the cheerleading squad. She went to the informational session. She was given the information about the requirements for tryouts. And she had to learn certain cheers. They had a week, they come back, they do the cheers or whatever long they had. But in this case, she wasn't given extended time to learn the cheers. I'm going to get back to there's a question about after school care located in the building. Let me get back to that one in just a second. When she wasn't given, so the student was not given that extended time to learn the cheers. And so she was cut from the cheerleading squad. And the coach in that case had absolutely no idea that student was entitled to extended time. Yeah, somebody just commented it's always cheerleading. Yeah, I mean, there is a lot going on with cheerleading. There's a lot of movement, there's a lot of memory. Yeah, I agree. It's something that can definitely come up where somebody may have accommodations that need to be taken into account. So this student was cut and the coach had no idea. So the student challenged being cut, filed a complaint with OCR and said, hey, I'm entitled to extended time. They did not give me extended time in the cheerleading tryout process, and that was discriminatory. They did not, they didn't give me the accommodations I'm entitled to as a result of my disability. And, she argued she was denied access to the athletic program because she wasn't given that accommodation, and that was a violation. And OCR agreed with that and said that that's right, because what is on your 504 applies across your program. Now, again, you may have that substantial limit, that reasonableness test that fundamentally alters the program. So that's something you can still take into consideration. But in this case, they didn't offer anything. They didn't even know. The coach had no idea. So another area where we get pushback on this is, districts will say, but the coach, this is FERPA, this is student privacy. We don't want the coach to know the details of the student's disability. No, that's just wrong, because the coaches are acting as school officials. They have a legitimate educational interest in knowing the students they're serving. So this is not gonna violate student confidentiality, because the coach has to know in order to provide the services. Now it may be limited how much the coach needs to know. I don't think that means that a coach is going to have full access to everything, but whatever the coach needs to know to be able to serve that student with disabilities, to be able to allow that student equal access to the program, they need to know. So they should be informed about the students that are on their roster. Yes, excellent question. This holds true for substitutes as well. If a substitute is not providing the accommodations on the 504, you're out of compliance. The sub has to know. Yes, absolutely. So someone asked about childcare in the building. Is that school care that is located at the school? So you, as as an educational institution, you can't have a program at your school, even, you know, through contractors, that is allowing discrimination. So you can't offer a program even through, if you're talking about like contracted childcare, it's going to be the same thing. You have to offer the same access, and it may look different in that setting because we're talking about a childcare setting versus a classroom setting. What they need may be different, but you can't discriminate on the basis of disability in a childcare program that you're offering after school either. So on the next, transportation home. Okay, hang on, let me pull this one up. What about transportation home from after school activities for a full-time wheelchair user if the wheelchair user wants to stay after school for extracurricular activities? I think that may depend. I think that might be getting a little too specific for a general answer. I mean, in general, if you know all of your students are required to access their extracurricular activities with their own transportation, there may be exceptions. I think you better you know, look carefully at the individual facts there. So on the next slide, procedural safeguards and dispute resolution. I want to talk a little bit about procedural safeguards. You do have a requirement, as we've talked a little bit about, to notify parents about the decisions that you're making. And you do have a requirement to tell them how to challenge it, to give them that notice of procedural safeguards that we call our "here's how you sue us" notice. It has to be provided to parents, and it has to be provided in their native language. There is case law on that. If you don't inform parents in their native language, you're not really giving them notice. That's not really notice if they can't understand it. So it does have to be communicated in their native language. Under 504, there are multiple ways to challenge a district's decisions. And how those decisions are challenged sometimes is dependent on, on the nature of the dispute, on what the underlying issue is. But remember, this is an anti-discrimination law. So that means districts have an obligation to protect against discrimination on the basis of disability. And that includes discriminatory harassment. And that applies across, all protected classes. But of course, we're talking about 504 today. But when you allow harassment to occur in your program, you're allowing someone to be treated differently on the basis of that protected class. So if someone's being sexually harassed, that's discrimination on the basis of sex. If a disabled student is being harassed on the basis of their disability, that is discrimination under 504. You're required to have a grievance procedure in your board policy. It's required by the 504 regulations to have a board policy, a grievance process that addresses complaints of disability-based discrimination. So that's going to include harassment. And you have to have at least one person in your district designated as the 504 compliance officer. Those are the people to whom a grievance can be presented. And a 504 compliance officer, and it should be right in your board policy who that person is, that may or may not be the Title IX coordinator. It may or may not be the civil rights, compliance officer. It could be someone different. I often see that there's some overlap, that, there's 2 or 3 people named in all these different positions, but you should definitely have that in your board policy and know who it is. The law requires that you have a procedure with appropriate elements of due process. So, notice and an opportunity to be heard, and that you must be prompt and equitable. So you need to be fair, you need to be, you need to be prompt. There's no requirement of a specific time frame, but your policy may have specific timeframes laid out. So I know my colleague, Melissa Bondi, when she presents on this topic, which usually she did it in person, because I think I started taking over on this topic with the series during COVID. So I don't think we've had an in-person since then, but she always likes to ask whether the audience can, by show of hands, do you know who your 504 compliance officer is? And I can't see because a lot of you have your cameras off. So I'm going to assume every single one of you raises your hand and that you say, yes, I know who my 504 compliance officer is in the district. If you don't, you might check, you might find that it's you. I have had people, honestly, I've literally had people be surprised when they went to their policy and found that they were the 504 compliance officer. So you should know who that person is, because if you become aware of a complaint of discrimination, someone who wants to present a grievance, you need to let them know who they can refer that grievance to. So your homework is to look up who that person is if you don't already know. But allegations of disability-based harassment need to be addressed under that grievance procedure. That's what your obligation is. And of course, if discrimination is found to have occurred, then you stop the harassment, you prevent its reoccurrence, you remedy its effects, you eliminate the hostile environment. When there are disputes, though, related to identification or evaluation or educational placement, parents can take you to due process. And that doesn't happen all that often, but if it does, if you find yourself in a due process situation, you are required to find a hearing officer, usually from ODE. You pay for that. And then you have an administrative hearing that's very similar to a trial. So you're going to have, swearing in of witnesses and testimony and cross-examination and a court reporter. And, all of this is done under oath. And then there's a transcript, and then the hearing officer issues a decision. So that's kind of what that looks like. Parents can also go to OCR and file a complaint, which, that's always available. And OCR, will take the complaint and investigate and reach a finding of whether or not discrimination has occurred or 504 rights have been violated. And then, of course, they can sue you in court. So, our recommendation and our best advice is to be proactive, to try to avoid those kinds of complaints in the first place, to try to prevent them from happening in the first place. There's a lot that can be done long before a dispute escalates. And it's really helpful if you kind of recognize the signs of that dispute, that it's coming down the pike, so you can try to head it off before it gets into that contentious, complaint situation. So the first thing to do, and I think this is on the next slide, is be trained on legal compliance. So here you are getting trained on legal compliance. So that's definitely helpful. Let's see. Yeah, make sure your staff have access to your policies and know what your policies are. And document compliance. It's really important to have good documentation. That's really the key, because if a school district is going to these great efforts and doing this great work to try to make their programs accessible to their students with disabilities, but they don't have good documentation of it, it's for naught if you get into a complaint. So you want to have good documentation. Make sure your staff members know who to call when they identify an issue. Know who that compliance officer is. Train your staff on good communication and conflict resolution techniques. And I can't emphasize this enough, because, this really very often comes down to communication. I have so many times dealt with disputes where, the parent just didn't understand what the district was trying to do. And it was because the district really wasn't explaining what they were trying to do or what their rationale was. And sometimes if you can just try to really open those lines of communication, because this is about working together, communicating effectively with parents and learning how to work out disagreements before they turn into complaints is really important. And then pay attention when you see something changing. If you see parents change their tone or change their mode of communication, there might be something wrong. Sometimes we'll have verbal communications with a parent, and then all of a sudden parents start sending very detailed emails. And these very detailed emails sound, eerily as though they were written by an attorney. They probably were. So if you start getting emails from a parent that don't sound like they're written from the parent's voice, and it may not be an attorney, it may be an advocate or a friend, but it means that they're seeking assistance from someone else because they don't feel like they're getting what they need from the district. So be on the lookout for that. If they start asking to record meetings, if they start making these broad, records requests, if they're, complaining about the staff on a regular basis, there's probably something brewing. So try to see what it is and try to see if it can get resolved before it's too late, before, it goes down that road. And then some bigger red flags: complaint that a child isn't receiving the services they're entitled to under the plan. Take those seriously. Really be thinking about, are we providing what is needed under the plan? And if we're not, why does the parent think we're not? Is it time to reevaluate? Is it time to get back together and think about whether or not the child needs different services? Because the parent apparently thinks they need something they're not getting. Is it because we're not implementing the 504, or is it because they need something that's not in the 504? So when you start hearing those kinds of complaints, take them seriously and think about what the next steps are. When they start bringing an advocate or an attorney to a meeting, that's obviously a pretty big red flag. When they start requesting private placement, when they start requesting IEEs, these are pretty obvious red flags that I'm sure you can all recognize, but they're signs that things could escalate. All right, so that is the nuts and bolts of the law. So what I'd like to do is take about a 10-minute break. So it's 10:01, so we can come back at 10:11. And then when we come back, we'll talk about some of the most common questions we get about 504 in our office. If a parent is specifically requesting a one-to-one aid, you need to come to the table and talk about it. I mean, it depends on the circumstances. So, all right, so let's take a 10-minute break and I'll see you all in about 10 minutes. Yeah, the next thing I'm going to do is talk about some frequently asked questions that we get about 504 in our office. So the first one is, if a student is not eligible under the IDEA, might they still be disabled under 504? And the answer to that is maybe. So look on the next slide and you'll see there's a chart. The yellow circle in the middle, those are students who qualify under the IDEA. So that means the student has a disabling condition that is defined in the IDEA that causes an adverse effect on their educational performance and needs special education. And then the blue circle is bigger. So that is going to include everyone in the yellow circle and more, because the definition under 504 is much broader. It's every student with a physical or mental impairment, as we've talked about, that substantially limits a major life activity. So it's much broader. And then if the student doesn't fall in that center circle, they can still fall within the second circle. So yes, the student who is not eligible under the IDEA may very well be eligible under 504. So keep in mind too, that when we're talking about 504, I keep saying it's an anti-discrimination law, and the language says an individual with a disability. So remember that it borrows from the ADA. It doesn't say child and it doesn't say student. So those 504 protections don't only apply to your students. It applies to the adults who work in your buildings. It applies, to the protections of 504 apply to students, to the adults in the buildings. It applies to the employees. It applies to visitors, and it's about accessibility. So because you're a recipient of federal funds, you have to make your programming accessible to students and employees and visitors. And because you have members of the public who want to access your federally funded program. That's why when you put on a school play, you might you pay for an interpreter. It's a very broad coverage. So anyone who's been in the schools for a while now, that 504 has certainly expanded, and it's a lot bigger than it was 15, 20 years ago. And it's because of that expansion in the regs that we've been talking about, and this expansion and broadening of the scope and the way we're interpreting it and reading it. And that's the way it was designed, because it's an anti-discrimination statute. So question number 2, do we need a medical diagnosis to establish an impairment? It's another question we get quite frequently. So you may recall the very first session in this series, I co-presented with Laura Anthony, and we spent some time talking about the difference between a disability and a diagnosis. And I can't remember if Laura or I did this part of the presentation. I think it might have been her, but she always has this reference to the letter people from the 70s. I don't know if you remember the letter people. It's a TV show where, the characters had letters, and the letters kind of, defined or explained who they were. But when she talks about the difference between a diagnosis and a disability, she talks about the big D and the little d. And the big D is the disability, and the little d is the diagnosis. And what we're talking about with 504 is the same as what she's saying under the IDEA. We're talking about the big D disability. Does not necessarily mean a medical diagnosis, and it is not necessarily required. So on the next slide, nothing in the law requires a medical diagnosis. But that being said, if you truly believe you need a medical diagnosis in able to reach a determination, you can ask for one. There's nothing wrong with that. Now, of course, you have to remember this is a free, appropriate public education. So if you want a medical diagnosis, you are paying for the medical diagnosis. You can't require a parent to go seek a medical diagnosis and pay for it. You have to do that at district expense. And you can't require it, of course, because the parent has to consent, but you can ask for it if you feel that you need it. In most cases, you probably don't. And if a parent refuses consent for a medical diagnosis when you really feel like you need one, you just have to rely on whatever information you have. And it may impact your determination, possibly, but if you have the information without a diagnosis, that's okay. So for example, let's say you've got this student that you suspect has ADHD, a child who you think isn't concentrating, but you don't have a diagnosis. So what data do you have to rely on? Well, you have records of their behavior, you have aptitude tests, you have achievement tests, you have academic performance, records of medication they're taking at school. That might give you some good information. Disciplinary records, reports or observations from teachers. You probably have quite a bit of information that you can look at to determine whether, this student has an impairment substantially limiting the major life activity of thinking or concentrating. So you probably have what you need without the medical diagnosis. And your obligation is to make your program accessible and not to diagnose. So you just have to do what you have with the data that you have, that you do not need a diagnosis if the data you have supports the determination without it. So to put this in perspective on the next slide, I do want to talk a little bit about ADHD. There is a Dear Colleague letter, one of those guidance letters from OCR. This one came out in 2016. So this one's been around for a little while now. It's a lengthy letter and a 35-page resource guide on ADHD. So they mean business when they're issuing this really substantive guidance from OCR. But this letter was aimed at school districts specifically identifying students with ADHD under 504. And basically, it said that OCR reached the conclusion that this was an entire population of students being overlooked. So it really supports the idea that schools need to be identifying these indicators and that you don't necessarily need a medical diagnosis to be able to pick up on it. But it basically said schools are failing because they're not identifying students with ADHD. And the resource guide is about the failure to identify and evaluate students who may need accommodations because of ADHD. And there's a ton of information in it. It says that the district staff are the eyes and the ears of the district for child find purposes. And teachers who are working with kids may notice things that could suggest that a student might have ADHD or an ADHD related disability, such as restlessness, inattention that's inappropriate for that student's age, trouble staying organized, difficulty organizing their tasks and activities, communication deficits, difficulty beginning tasks, difficulty staying organized, recalling information, rushing through tasks, producing messy work with careless mistakes, and difficulty completing assignments. So those are the kinds of things that district staff are able to just observe. You don't have to have a medical diagnosis to pick up on those kinds of indicators. I don't know about you, but that does sound like an awful lot of young elementary school kids that I have come in contact with. But what they're really trying to say is that you need to be paying attention. These kinds of things that you're observing might be telling you that you have a child find issue and you have an obligation to program for these kids. So the guidance or the resource document goes on to say that while a medical diagnosis may not be required, OCR will presume that when there is a diagnosis, unless there's evidence to the contrary, then the student with ADHD is substantially limited in one or more major life activities. So let me kind of break that down a little bit. So, we typically say special education is not a prescription, right? We are the educators, and, you all as educators are making those determination decisions. Doctors are not educators. So, a doctor can't write a prescription for an accommodation and say, this child has this condition, and so this is what they need, and then present it to the school. That is information you have to consider, right? Because it's additional information or data about that child, but you don't necessarily have to follow the doctor's directive in general. But what this guidance says, that if a doctor diagnoses a child with ADHD, unless you have other evidence to the contrary, we're going to presume that child qualifies under 504. Now, whether or not they need programming, as we said, those are two separate questions. So we'll talk about that a little bit more in a minute. But it does say that if you have a medical diagnosis of ADHD, OCR is going to presume that that child qualifies under 504. But that doesn't mean you have to have it. If you can't get it, if the parent won't consent, if you don't have the diagnosis, but they have all these other indicators, they still may qualify. So they want the district staff, those eyes and ears of the district, to be really paying attention to those kinds of indicators. So basically, if you know the child has that ADHD diagnosis, you're going to presume they have a substantial limitation of one or more life activities, and you're done unless there's evidence to the contrary. Now, to have evidence to the contrary, you would need evidence from your staff that this child is able to concentrate in a distracting environment, is performing well, is not distracted, has neat homework. They're turning things in, they're doing their work timely, they're not making rushed and careless and messy mistakes, that kind of evidence. And if you don't have it, OCR is going to presume that it qualifies. Is a medical diagnosis required for ACT, SAT accommodations to be honored? I don't believe so. There are
ACT requires that.
ACT, thank you.
Yeah,
Thank you.
depending on the disability, they may require that
Yeah.
diagnosis.
Right. I do think it depends on the specific diagnosis and what the accommodation is, but ACT and SAT have separate rules of their own, because those are, they have separate rules because they are, they have their rules that are related just to their testing for their own purposes. So, yeah, so I think it depends, but perhaps with ADHD, Erin, do you happen to know, is that one where they do require it for ADHD?
Most recently for students that I have had to request the accommodations, they have asked for that specific diagnosis.
Okay. Okay, that's really helpful. Thank you. So the takeaway though is that you can't use the academic success of the student to conclude that they're not substantially limited, that they're not substantially impaired. Because somebody with ADHD may have a high level of success, but nevertheless be limited in a major life activity due to their impairment, because they have to put in additional time or effort in order to reach that level of success. So they're getting all A's, but it's taking them 8 hours to do their homework when their peers are doing it in 1. Or a parent telling you, hey, my child is completely stressed out. What the parent is telling you is that the child is, that they're using mitigating measures. They're doing something more to compensate for that disability, and they may require programming. So be aware of those arguments. I think that OCR letter, it's summarized in the materials, but I definitely think it's worth a read. So on the next slide, did you really mean it when you said we can't consider mitigating measures? So let's talk about, so kind of speaking of the ACT situation, the child we talked about earlier, diagnosis of dyslexia, top 10 in his class, doing really well, wanted extended time on the ACT. And the district didn't do an evaluation because they said, no, you're doing great. We don't think that you qualify. OCR said, no, you looked at him in his mitigated state, you need to reevaluate. So after the OCR complaint, the district went back and they evaluated him and they considered him in his unmitigated state. And they said, you're right, you do qualify. You qualify as a student with dyslexia when they considered this kid in his unmitigated state. But any accommodation they would have given him, he already had. He had learned them on his own. He was doing it on his own, but he didn't need anything. So just remember, like I said, it's that two-part question. If they qualify as an individual disability, do we need a plan? And in this case, the student did not need a plan. So can you have a student who qualifies but doesn't need accommodations? The answer is yes. So what do you do with that kind of a child? Well, there's language in the Dear Colleague letters on this issue. I believe it's on page 12 of the materials. It's from an OCR Q&A from 2012. So this is 10 years old. And it says, although school districts may no longer consider the effects of mitigating measures when making a disability determination, they remain relevant in determining the need of a student with a disability for special education and related services. So you cannot consider the mitigating measures to determine whether they qualify as an individual with a disability entitled to anti-discrimination protections under the under 504. But you can consider it when determining what their needs are and whether they need a 504 plan. Okay, so it's the second half of that question. So you can consider mitigating measures in determining whether they need accommodation. So they're protected from discrimination, but they may not need special education related services or accommodations. Okay, on the next slide, if the student doesn't need services or accommodations, oh, I think that was the last one. Sorry, you can go one more. What responsibilities do we have? Sorry, I'm in the other direction. One more slide. There we go. If the student doesn't need services or accommodations, what responsibilities do we have? So what do you do? So what are your responsibilities to a student who qualifies but doesn't need services or accommodations? So on the next slide, you provide the notice of procedural safeguards. You make sure you tell the parents, this is what we did. We did an evaluation. We determined that this student is a student with a disability. But we also determined that this student does not need services. So we're not writing a 504 plan. And then you provide them, with notice of that decision. We met on this date. This is what we did. This is what we decided. Here is the notice of procedural safeguards. And you don't provide services and you don't write a plan. You don't have to write a plan just because they qualify, because there are times when the student with a disability does not need accommodations and related services. So they don't need a plan. Okay, so on the next slide, we don't usually start getting this question until about March, but do we have to send a medical attendant on the spring break trip? My entire 8th grade is going to DC, and I've got a student who needs a medical attendant. Do I have to send the medical attendant on the trip? I actually don't know that we've gotten this question much because there hasn't been as much school travel recently, but that's picking back up. So the answer to this is maybe. Again, this is a statute about access. If a child needs a medical aid to access our district sponsored program, including our field trip, our overnight trip to DC or wherever we're going, then the aid has to go. You can't deny them the benefits of or participation in our program, in our federally funded program. And so if they have to have a medical attendant with them to be able to access it, then it is the district's obligation to provide it. So the special ed director gets on the phone with the superintendent and says, we need to send the aid. And the superintendent says, whoa, this is going to cost a fortune. Do we really have to do this? But the answer is yes. So the next question is, can I make the parent go? We get that question sometimes. If we want to have the parent go instead, and the answer to that is no. You can't require the parent to go. If you're not requiring the parents of other students to go, then you can't require the parent of a student with a disability to go, because that's treating them differently on the basis of their disability. Now, that doesn't mean you can't ask. Sometimes the parent wants to go. Sometimes the parent thinks this is going to be a whole lot better for my child. My child's going to be safer. I'm going to be able to ensure that my child gets what they need, if I decide to go. So I want to go. Now, the child may not be really excited about that, but that's a different story. But you can absolutely ask the parent if they would like to go. Some parents want to. That solves your problem, but you can't require it. So, but do you have to pay for the parent to go? Well, you'd have to pay somebody else. So probably, but sometimes, with consent, you can do a lot of things. Sometimes you can work out a good compromise. Like we're gonna cover the, we're gonna cover the room, but not the meals, or we're gonna cover the airfare, but not whatever. But if you can get in a situation where you're not fighting over it and you've got consent and we're in agreement, then you're good to go, as long as the child has what they need and the parent is agreeable to that. What about excluding a student from a trip because of their disability, if their behavior is really bad or if they are medically fragile? So I obviously would caution against denying participation to any student with a disability, but that's not to say that there are not legitimate, non-discriminatory reasons why you might need to exclude that student with the disability. So for instance, if the student's behavior is such that they've been suspended or expelled, let's say you've got an across the board, policy that says a student who has been suspended or expelled is not allowed to go on this trip. And that applies to students with disabilities, and that applies to students without disabilities. If you've got a uniform, policy like that applies to everybody, that's not discriminatory. If it applies to everyone, you can also, sometimes we see that students have to have a GPA of, 2.5 to be able to go on these kinds of trips. Those are legitimate non-discriminatory reasons, as long as you've got policies that you're applying equally. So sometimes we're asked about excluding a student from playing sports because of a disability. So for example, we had a situation with a student who wanted to play basketball, but the student had been in a car accident and they had a traumatic brain injury. And they wore a protective helmet, but the kid wanted to play without the helmet. it's easier to see, it's easier to run around. The kid didn't want to have the helmet on playing basketball. The superintendent did not want them to play this sport. This is a contact sport. This could be dangerous, and certainly didn't want them to play without their protective gear. But the parent didn't want them to have to wear this helmet. So what do? Well, you get the best medical information that you can. In this case, the parent signed a release, which was very helpful, and the school got to talk to the doctor, and the doctor said, I would never allow this kid to play a contact sport without the helmet. And actually, I wouldn't let this kid play with his helmet, because this is dangerous, and the child should not be involved in any contact sport at all. So now we have a legitimate medical reason to deny the child the opportunity to participate. The doctor said this child's participation creates an unacceptable risk to the student's health or safety. So that's the standard. Unacceptable risk to the student's health or safety. So get the best medical information that you have available to you, and figure out what the student's limitations are. Now, what about a child who's having seizures? We talked a little bit about episodic impairments. These seizures don't occur every day, but they occur occasionally. So we've got this episodic impairment. There is a case in your materials about a district that put specific protocols in place on what to do for that child's safety. And it said in their protocol that they had established for this child, in advance, like maybe at the beginning of the school year, if the child has a seizure on the day of a field trip, they can't go. So that was reasonable. In this case, the court held that was reasonable. There had been 19 field trips that year. It's a lot of field trips. This must have been way pre-COVID. And the student was allowed to participate in 18 field trips, because on those 18 days, the student did not have a seizure. But on the 19th field trip, the student had a seizure. The protocol said, if you have a seizure that day, you can't go. They didn't let the child go. And the court said that that is reasonable. Because when the medical condition was not an issue, they allowed the student to participate. So it was really helpful, I think, in this case, that the school had a protocol that they were following. And it goes back to this standard of whether the child's participation poses an unacceptable risk to the student's health or safety. And the school had said, if this child has had a seizure that day, we're not going to let them go because it poses that unacceptable risk. So the decisions do have to be made on solid medical evidence, on the information you have available. It can't be an assumption based on the condition. It has to be specific to that child. So do 504 plans apply in the context of athletics and extracurriculars? Yes, absolutely. We did talk about that a little bit. We learned about our cheerleader earlier, right? Our cheerleader who didn't get her extended time to learn the cheers. So I'm going to tell you the rest of the story about that cheerleader. So she came back the next year after she had her complaint with OCR, and they said, whoa, you discriminated against her because you didn't give her accommodation. So she came back the next year. She tried out for cheerleading again. And she was given, the coach had a rubric to follow in selecting the cheerleaders. And the coach gave her the accommodation she was entitled to under her 504. And, we advise the coach, use that rubric, apply objective criteria to the decision, but give the student her accommodations under 504. So that's what they did. And guess what? She still didn't make the team. So she filed a retaliation claim this time. And she said that the district was retaliating against her for her previous complaint. Even though they gave her accommodations, she didn't make the team. It wasn't because she wasn't, qualified or wasn't as good as the other kids who tried out. It was because they were retaliating against her. And so we said, okay, well, we knew this was coming. And that's why we said objective criteria, let's use the rubric. So coach, whatever, give me your rubric. Let's see this so we can defend this. And the coach said, oh, well, I used a rubric, but I threw it away. I don't have it anymore. So that was kind of a bummer. The important thing is to have legitimate, non-discriminatory objective criteria, and then document it and don't throw it away. In this case, the coach ended up reconstructing it, providing an affidavit that this was the objective criteria that was applied, and this is what they did, and this is why the student didn't make the squad, and was found not to have discriminated against this child because they did not do this in retaliation. And the recreation of it certainly better than nothing, but it goes back to that documentation I said earlier, right? Document, because that's your proof that you are not discriminating against the students. So how does the coach know what accommodations a student is supposed to get? I said earlier, we do sometimes get pushback. I hear school administrators say, oh, we can't give that information to the coach. Someone put in the chat earlier, what about subs? Same deal. Districts really need to get coaches, they need to give them the notice. You need to make them aware. So districts should review the team rosters with the coaches. The coach should be working with the school to review the roster, see if there are any students who have, who have accommodations that they're entitled to, see what they're entitled to, and let the coach know so that they can provide those. This is not a FERPA issue. They have a legitimate educational interest in this information in order to allow those students equal access to the program. So they need to know. Accommodations, they have to apply across all settings. So thinking about what is reasonable, again, we talked about that fundamental alteration of the program. While you do have to provide accommodations to allow equal access to your extracurricular activities, you don't have to fundamentally alter the program. You have to provide accommodations that are reasonable. So a couple of examples. You've got a basketball player with a hearing impairment. They may need an interpreter to allow them to communicate with their coach or with their peers. If you've got a student with migraines, they may need to be permitted to have an alternate tryout day if the migraine, presents on the day of tryouts. That might be the kind of reasonable accommodation that you would offer to a student with a disability. There's a case at the bottom of page 15 of your handout about a student with an emotional disturbance who had it in his IEP that he would be given re-queuing. He would be permitted to line up last for activities. That was part of his accommodations across the board in his IEP. And he was on the golf team. And the golf coach just didn't think that that was something he should have to do. He said that it would be unfair to the other kids on the team to do the re-queuing because that's like extra coaching and it's not fair. He said it would be unfair to always let the student go last, that other kids should get, they should, trade off and alternate. So the student filed a complaint with OCR. The coach tried to say this was a fundamental alteration of the program to do this, and OCR disagreed and said, no, that is not a good excuse. The accommodation does apply in the context of the golf team because that's not a fundamental alteration of the program. So takeaway, notify your coaches, know what's required, make sure they know and understand that they need to use non-discriminatory criteria for selection. It's not automatic access. I mean, don't get me wrong, a student still has to qualify, but they have equal access. So discuss accommodations with coaches and then revisit those conversations when necessary. All right, so on the next slide, can you provide a list of reasonable accommodations? Sadly, no, we cannot do that because it depends. So the scope of services and accommodations, the lengths to which you must go to accommodate a student with a disability, sometimes board policies and 504 forms, if you've got your, your prefab forms, sometimes there are checklists, kind of like a menu, like let's pick this and this and this. And the parents say, I want that and that and that. That's really not the way it's supposed to go. It's an individualized discussion, right? And it's an individualized determination. I can't give you a complete list. It can be anything. Nothing should be automatically off the table. If you ever are saying we don't do that, that's a sign that you're not making an individualized decision for this child. But those menu items certainly can help get the conversation going, but that should not be an exhaustive list if you do have those kinds of check boxes and lists of what accommodations are available. That can't be the limit because the sky's the limit. So the question is, how far do you have to go? And again, it's that fundamental alteration of the program. So this comes up a lot with twice exceptional students. And then, to really understand your obligations, this is one of those areas where we borrow from the ADA. You have an interactive discussion with the student and their parents to determine what they need, how you can accommodate that need, and whether or not that fundamentally alters the program. So, when an employee comes in the employment setting under the ADA and they say, I need X because I'm disabled, the employer is required to sit down with the employee and engage in this interactive discussion. What's reasonable? What can we do? And they have this back and forth conversation. That's what the ADA requires. And that is also what is required under 504. It's the same thing with your students. So when I'm defending where we finally draw the line, it's very helpful if we can say that you made some accommodation. So the parent asked for this and we determined that this was reasonable, not the parent asked for this and we said, no, sorry, we can't do that. So we offered nothing. You know, if extended time, you know, they want this extended time for the AP class and your answer is no, we're not going to give them any extended time at all because it's an AP class that fundamentally alters the educational program. You know, that's probably not going to fly. But you don't always have to give them everything they ask for. So if they say, I want, you know, double time and you say, we're going to give you an extra, you know, 25%, you know, whatever is reasonable that does not fundamentally alter the nature of the program. So when a requested accommodation is not given and it's challenged, it's just much easier to defend if we can say we gave something. So even if they conclude what was requested, you know, was a fundamental alteration, then you dial it down to something that isn't a fundamental alteration. So we have a case involving a high school swimmer. This was a female young woman, wanted to join the swim team, but had a fear of drowning. I don't know why she wanted to join the swim team. Maybe it was some kind of, you know, effort to overcome her fear. I don't really know, but she wanted to be on the swim team despite this fear of drowning. You know, exposure therapy. But in any case, she wanted to get in the pool to face her fear. And so she tried to join the high school swim team. But she went to the swim coach and she said, I have a disability. I need an accommodation. I need to be able to leave the pool if I'm having a panic attack. And that may happen in the middle of a swim meet. And the coach said, that sounds like a fundamental alteration of the program because we need you here on deck and we need you in the water. And we cannot accommodate you by allowing you to not swim when you are a member of the swim team and the whole purpose of the program is to swim. So that's a fundamental alteration of the program. So they said, no, you can't engage in competitive swimming if you leave the pool. So they said, no, they're not going to allow that accommodation. The family filed suit. They did not file a complaint with OCR. They went right straight to federal court and filed their complaint. And they alleged a denial of a reasonable accommodation in the athletic program violated the students' rights to access their program under 504. And the court said, no, that is a fundamental alteration of the program. So I think common sense definitely prevailed here. You can't leave the pool in the middle of a competitive swim meet and still be a part of the swim team because you are not engaging in the activity. Staying in the pool is an essential aspect of being a swim team member. And so that was held to be a request for a fundamental alteration. So it took us to the logical conclusion. Not that I'm cynical at all, that does not always happen. But you have to go pretty far to say it's a fundamental alteration, but I think not swimming on the swim team is far enough to call it that. So another thing that's really hard to defend is if your reasoning for not providing the requested accommodation is that you say it's too expensive. I know that's a real concern. It is a valid concern, but when it comes to OCR's review of whether or not an accommodation is reasonable, they're going to look at the cost in relation to the district's entire budget, not just in relation to the district's, budget for that program or, budget for that school building. What they're asking for, it's almost never going to look unreasonable in light of the school's whole entire budget. So cost is probably something you are going to lose on. So I would caution you against even mentioning cost when you're having these discussions, when you're having this interactive discussion with the student and their parent. So fundamental alteration, no bright lines, but that gives you some idea of what might happen when you get involved in those kinds of discussions. All right, number 8. Must a school conduct a manifestation determination for a student protected by 504 before imposing a disciplinary removal of 10 days or more? This does come up. We know that students get a manifestation determination under the IDEA. Do they also get one under 504? And the answer is yes. Remember that you have to evaluate at the initial determination before a significant change in placement and when conditions warrant. So yes, because if it's more than 10 days, it's a significant change in placement. So if you are going to, now if it's fewer than 10 days, OCR has found that it is not a significant change of placement. And so just like under the IDEA, a series of suspensions that, that the cumulative total is 10 days or more, that is a change of placement. So we're going to use that same kind of analysis to determine whether we're talking about a change of placement, but we still have to have the manifestation review for a 504, just like we do for a student under the IDEA. In fact, this manifestation determination review concept predates the IDEA. It existed in 504 long before the IDEA was ever even adopted. So the idea is, if we're taking a child out of our educational program because of something related to their disability, that is the ultimate act of discrimination. So what do? You do an evaluation, you make sure you're not denying the student access to your program because of that disabling condition. So yes, the answer is you do have to do an MDR for 504 students. So go back and think about, at the very beginning, we talked about individuals who are entitled to protections. Yes. Oh, sorry, I thought somebody had a question. Go back and talk about the individuals who are entitled to protections under the IDEA. Under 504. There may be people entitled to protections who don't have a plan. Remember, we talked about students who have a record of impairment but don't have a plan. If they're entitled to protections under the Act, they're still entitled to an MDR before they're excluded. So that doesn't come up very often, but you should be aware of it. If the lawyer says my client had a disability 8 years ago, you can't discriminate against them on the basis of that disability that they had 8 years ago. So, but here's the big difference between 504 and the IDEA. When you do exclude a child for more than 10 days under 504, after the MDR, you say this was not a manifestation, child's excluded, 10 days plus whatever the time period is, the services stop. Right. So under the IDEA, as you know, if a student's on an IEP and they're out more than 10 days, if it's not a manifestation, you can exclude them for that period, but you still have to provide their IEP services, not so under 504. So under 504, no requirement to continue their education during the period of removal. So that's a pretty significant difference between the IDEA and the 504. So the exception, of course, is if you provide education to your gen ed kids who are suspended or expelled. So you have to treat them the same. You can't treat them differently from your students who are non-disabled. So, again, always go back to that fundamental concept that this is an anti-discrimination statute. So if you routinely allow students who are expelled or suspended to attend ISS or to have alternative programming to continue their education during that period of exclusion, however long it is, you need to make those same opportunities available to your students who are protected under 504. And it may look a little bit different depending on what their needs are, but if you're allowing that continued programming to other students who are suspended or expelled, then you need to also offer continued programming to your 504 students. If you do an MDR, if you're having that MDR meeting, who has to be there? So again, we have this big distinction between 504 and IDEA. You do not have to have that properly constituted, team under the IDEA. You need the same people who are required for an evaluation under 504. So that's people who are knowledgeable about the student, knowledgeable about the disabling condition. Those are the people who are going to get together and make this determination. All right, so on the next slide, does a failure to recognize harassment violate 504? I kind of talked about this one earlier. I gave you a spoiler. Yes, it absolutely can. There is I think a flow chart on the next slide. So we have been told as far back as 2000, and it is almost 2023. So 23 years ago. Okay, the question just popped up. Let me come back to that in just a second. That disability harassment, including harassment, discrimination or harassment on the basis of a disability, discrimination of a student, harassment of a student on the basis of their disability can interfere with FAPE, and therefore it is a violation of 504. So if a child is bullied and they're not having equal access to your programming as a result of that bullying, you've got a situation where the student is denied equal access to your federally funded program because of their disability. So back to the language, we're denying them the benefits of that program. We're denying them participation in that program. Now, there are several Dear Colleague letters on this. One in 2000, there's one in 2010, and they're very sweeping and extensive. And they very clearly state that you need to address the bullying and harassment and take steps to remedy that conduct. This slideshow shows you kind of an outline of what it's supposed to look like. Access your policy, respond immediately, do an investigation, document that investigation, stop, prevent, and eliminate the harassment, and convene the team and see if there are additional supports or needs that that child may have as a result of, of this situation. So keep in mind, we can't control what students do. We know that. You can teach the golden rule. You can tell your students to be kind. But we can't always control whether or not they are. But what you can control is your response to that conduct, your reaction as a district. And that is what your responsibility is. You try to teach the good conduct, and when it doesn't happen, then you address it and react to it. So ultimately, when there is liability for a situation like this in a district, when you have a situation where this is being litigated, you've got a student who says they've been denied their education because of the bullying, and the district was deliberately indifferent to that bullying. You're potentially looking at how to pick up the pieces after, a student suicide. Or, the parents come back and say, my child was being bullied and you knew it and you didn't do anything about it. Those are the cases that can end up with big liability. Obviously, you never want that to happen to a student, and you don't want to be the school in the headline if it does happen to your student. So you want to be able to show that you've done everything you could do. It's when the district can't show that they responded appropriately when they were put on notice that student was being bullied or harassed. So you want to be able to show that you've responded appropriately and that you followed your policy and that you've documented that. So if you are put on notice of any bullying or harassment on the basis of disability, and like I said earlier, this will apply to any kind of harassment on the basis of a protected class, whether it's race or religion or sex or disability or any, any protected class, you want to respond immediately as soon as possible. Bring the parents in. What's the problem? Conduct an investigation. Look at your policy to see who the appropriate administrator is to conduct the investigation. Depending on the type of complaint, your policy may direct who it has to be. Sometimes there's a designee in there, but sometimes there's not. If you're looking at sex discrimination, we know we have to have a separate investigator that's different from the decision maker. So there are all kinds of different policies and procedures at play that can be very confusing. And there's also overlap. So, you need to be thinking about which policy you're following in situations where you've got, what if you have sex discrimination of a student with a disability? Then what do you do? Which policy are you following? And those are pretty complex questions. Those are definitely times where you're going to want to consult with legal counsel. But start with your policy, know who that compliance officer is, with respect to whichever policy we're looking at. And it may be different, but whatever board policy applies to the complaint, there's going to be an investigation of some kind. It may look different. It might be simple. It might be just interviewing the student, or it might be, super involved, but whatever the facts are, you're going to investigate, and then you're going to document the investigation. And then that middle box on the bottom line there, stop, prevent, eliminate. That's what you have to do when, after the investigation, you determine that harassment or bullying took place. And then the last step for students with disabilities, as I said, is that there's probably something that could or should be done with the student's 504 or with their IEP. It's going to be the same. So it might be that they're entitled to comp ed if they've been missing school because they've been afraid to come to school, or it might be that they need social skills training. Sometimes maybe part of the reason they were bullied is because they didn't understand personal space. They stood really close to people, or they were touching people, and then other kids were making fun of them. So that might be a situation where, some social skills training is necessary for that child to help prevent and eliminate future occurrences of that bullying. It could be because of hygiene. So maybe you need to address the prevention in their 504 or IEP. It looks like, okay, we've got a couple of questions that popped up. Let me see. Can you talk more about 504, and is it a manifestation? So, it depends on the disability. If you've got a student with a disability and the misconduct that they've engaged in is because of their disability, If they have ADHD and they engaged in some very impulsive conduct that violated the code of conduct, it might have been because of their ADHD, because of their inability to control this impulsivity. That's a situation where you may determine that it was a manifestation of the disability, and therefore you can't exclude them. You can't change their placement without an evaluation. So you do an evaluation, you meet at the table, you figure out what's going on. Can we take into consideration how an accommodation may impact other students' ability to learn without interrupting or disruption when discussing a 504 plan? So, again, your obligation is to that student. I mean, if you're talking about a situation where they have behaviors that are interrupting or disrupting other students' ability to learn, you may be looking at doing an FBA, putting in a behavior plan. That behavior plan may or may not result in, we see it all the time where the first step in the behavior plan is when the disabled student is exhibiting behaviors, the rest of the class leaves the room until they de-escalate. Sometimes that's what's needed. It's an individualized decision, so it's going to depend. All right, the very last question I have on our top 10 questions that we get is, what should we do to lessen our complaints? Because as I said earlier, we talked a little bit about some proactive things that you can do, and these things really should not be overlooked, because when you look out for those red flags, it can keep you from a lot of headaches down the road, right? So some things not to do. We talked about things to do. Here are some things not to do on the next slide. Double negative here, but don't not provide procedural safeguards. So provide procedural safeguards. That's something that you don't want to be caught as the district who never gave the notice of procedural safeguards. Putting an obligation on the parent to trigger the evaluation. And I have had this come up a lot, and I don't think it's out of a desire to not evaluate kids, but sometimes it's just out of a lack of understanding of what the obligation is. If you suspect that a child has a disability, see something, say something. You can't just rely on the parent for the referral. You do not have to wait for a parent referral. And if the signs are there, you have the obligation independently under child fine. In light of that dear colleague letter that I talked about the ADHD, you're the eyes and ears. You have the burden of looking for children who need special education and related aids and services. That's part of the obligation. That's your child fine. You do need parental consent. So if you suspect a disability, you see those needs, you try to get consent, and if they refuse, okay, well, then your hands are tied, but then you document that and you've fulfilled your obligation. But you should not just wait for parents to ask. Even though you need their consent, you affirmatively have a duty to reach out. Not training on 504, not conducting staff in services. Staff needs to know what's at stake. They need to understand the obligations. What they're seeing may put you on notice, put the district on notice of a child find issue. And so they need to know what they need to do in that situation. So training on 504 is pretty important. Teachers need to know that if a student has a 504 plan, they're obligated to follow it. That's part of the training. And again, that's something that some people do sometimes push back on. They think they shouldn't have to. And we see it a lot, as I think I've said before, with twice exceptional kids, when you've got these high level teachers of high level academic challenging classes who don't want to follow the 504, but they're required to. They need to understand that. Something that's not on the slide is not using the phrase, tell me more. The more you know about a child, the better able you are to provide services for that child, and the more comfortable the parent is going to feel if they know that you're interested in that child. Tell me more. Get all of the information you have. Tell me what you think. If they want a therapy dog, tell me why. Explain this to me. What are the needs? Why does the child need that? What will this dog do for your child? Why? Engage in that interactive process. They may say, my child needs this because it will reduce the child's anxiety. And your response might be, okay, well, let's talk about other accommodations that might be available to reduce the child's anxiety. Don't make the child responsible for the plan. Sometimes I see things like that written right into the plan, that it says the student shall do X. Then if the student doesn't do X, guess what? You're not in compliance. It wasn't something you didn't do. So you want the duty to be on the school the way it's written. If the student getting support, it should be something that's checked by staff. Like, they're supposed to have their assignments reviewed at the end of the day. That responsibility should not be on the student. It's got to be on the staff member. Nothing wrong with working toward independence and having fading support. I'm not suggesting that at all. But if the student is not seeking an accommodation that's on their plan, you should put the team back together. And you should say, maybe the student doesn't need this anymore. I just had a due process filed in against a district just 2 weeks ago, where the allegation was that the district was not providing these, specific accommodations that were in the students. In this case, it was an IEP, and those accommodations, some of them were in there, some of them weren't, but some of them were in there. And the reason the district wasn't providing those accommodations is because the student was refusing them. And so the answer to that is not to say, well, the student's refusing them, they don't need them anymore. The answer is to pull the team back together and consider whether or not revisions to the plan are needed, because they weren't following the plan. I mean, that was factually accurate. Okay, so I have a question. Would you consider it a best practice to require the school psych to attend an MDR to determine whether or not a behavior is a manifestation of a disability? I don't think that it's ever a best practice to require it in every situation. I think, again, it's going to depend on the facts. If the interpretation is based on something that the school psych has unique knowledge of and, unique experience that they can help, that might be necessary, but it's just going to depend on the disability. There might be times where the teacher and administrator certainly feel qualified. But I guess if you've got teachers and administrators who are saying up front, in this situation, I don't feel qualified, we need the school psych. Why wouldn't you have the school psych there? Go ahead and do that. Yeah, absolutely. All right, so it is 11 o'clock and we have 30 minutes to go. The last thing I'm going to do is I'm going to talk about a scenario involving 3 students, and I think it's in your materials. I hope it's in your, is it in the last? Let me see if it's in there. I think it's in the materials if you want to follow along. I'm going to read it out loud. Yeah, it's a little bit long, so I know I've been talking for a while. So, it is in the materials. Excellent. So you can follow along. That'll help. Okay, so we're going to talk about a what would you do scenario, as I said at the beginning, and then we're going to talk through together some questions about how to handle this situation. So, a new family has moved into your school district, and only 2 weeks later, you have 3 voicemails from mom, one regarding each of her 3 children. Although the children's enrollment paperwork does not say anything about any of the children having a disability, mom is now requesting various accommodations for each child. So we're going to talk about each one. I think Maya, on the next slide, we'll talk first about Fishy Phillip. Fishy Phillip is a 1st grader who apparently has a very serious seafood allergy that is triggered not only by the ingestion of seafood, but also by skin exposure. Someone just asked if the outline was provided at some point. I think there were some messages in the chat earlier that it has been uploaded to your folder. So everyone should have the outline. I don't know if there's any follow-up question or if anybody from SST knows, but my understanding is the outline is out there. Okay, so this allergy is triggered by the ingestion of seafood and by skin exposure. So mom's voicemail, she shares, in the past, this allergy has caused anaphylaxis, a severe whole body allergic reaction to a chemical that has become an allergen. So symptoms of anaphylaxis can include closed airways, hives, nausea, vomiting, heart palpitations, and even unconsciousness. Philip's mom is requesting a healthcare plan to ensure that his lunchroom will be completely seafood free and that his lunch table will be thoroughly wiped down before he uses it, and that he will have access to his EpiPen at all times at school. Other classmates at school have food allergies, so some of these requests, like wiping down tables and carrying EpiPens, are not new to you or your school staff. Therefore, you suspect that your school staff will not see the need for a health plan for Philip. After her voicemail to you about Philip, mom wrote you an email complaining that for the 2nd Fish Stick Friday in a row, another student has approached Philip's lunch table waving a fish stick in his face. kids. So she writes that Philip is now very anxious about going to lunch because of that incident. And mom indicated that she has had great difficulty getting him out the door to school today. Philip is telling his mom that he won't come to school tomorrow. All right, then second child on the next slide, we have Wheezing Wendy. Wheezing Wendy is a brilliant fourth grader, and she has asthma. In mom's second voicemail, she tells you that Wendy's asthma seems to be exacerbated by strong smells, such as cleaning supplies or the new Katy Perry perfume that nearly every fourth grade girl seems to drench herself in every morning. The other day, Wendy had an asthma attack before a big test, and her mom had to be called to administer an inhaler to her so she could go back to class. Your school nurse has shared with you that she tried to explain to mom that she could fill out a form so the inhaler could come to school with Wendy, but mom is insisting that Wendy have a 504 plan instead. Wendy missed a substantial amount of school last year due to asthma-related issues, but her inhaler is typically all she needs. Your school nurse thinks a healthcare plan and administration of a medication form would be sufficient to address the issue. And then last, we have the oldest child in the family, gluten-free Gloria, who is a seventh grader on a gluten-free diet due to problems concentrating while in school. Mom, in her quest to help her daughter with her concentration issues, found this diet on the internet. Mom heard from Gloria's teachers that she's had trouble organizing tasks and activities, completing assignments, and paying attention in class, but has noticed that after going gluten-free, her grades and focus seem to have improved. However, the other day, Gloria apparently ate a birthday treat that a classmate passed around, and then she scored very poorly on her test for the rest of the day, even worse than she had been doing at her old school, where she was not exactly a stellar student. Mom wants a guarantee that the school will maintain Gloria's gluten-free diet at school, and wants this accommodated through the National School Lunch Program. Gloria's teacher tells you that she offers alternative allergen-free treats to every student, but that Gloria turned it down and knowingly went for those cookies. I bet the cookies were better than the gluten-free treat the teacher was offering, but nonetheless, that is what happened. So those are your three students. We've got Fishy Philip and Wheezing Wendy and gluten-free Gloria. So we're going to look at these under the framework of, first, we're going to assess whether any of these students is suspected disabled. If so, what their suspected disability is. And then we're going to talk about what the next steps are for each student. So let's start with Philip with the allergies. So Fishy Philip, he's got this severe reaction to seafood. So is Philip likely disabled? Your choices are: one, that Philip is disabled and would develop, and we should develop a healthcare plan; two, disabled and develop a 504 plan; or three, Philip is not disabled. So since we're in person, or since we're not in person, we're not going to do a show of hands. We're just gonna, I think it's on the next slide. I think it gives us your answer, which is one more. B. Okay, so Philip is disabled. His seafood allergy is severe. We're talking about an anaphylaxis. It renders him substantially limited in the major life activity of eating and breathing, right? So he's going to qualify. Now, we could address this under a healthcare plan, possibly, but if you do that, you might not be checking all the compliance boxes. So I would recommend going through the whole 504 process. And you should know that if you have OSBA policies, and maybe even with Neola, but OSBA policies almost always say that you will address all food allergies on a 504. So you should evaluate with consent. You should convene a group of people who are knowledgeable about the student and the data and the placement options and write the plan. So what's the plan going to look like? Now, do you think it's an appropriate accommodation? I think on the next slide, Maya, to create a seafood-free lunchroom. Is it an appropriate accommodation to have Philip eat alone, or neither? So let's go back. So there are circumstances where the severity of the allergy requires you to have an allergen-free environment. I would want to have the best medical advice I can get, ask for a release, talk to the doctor. We're trying to keep this kid safe. There is a case out there on a peanut allergy where a doctor said, this is the worst peanut allergy I've ever seen. It's airborne. If it's in the building, it can go through the HVAC system, and ultimately this child could die. That's one of those situations where we sometimes have to get in debates with parents over, one child's right to eat peanut butter. It does not supersede another child's right to live. But in this case, that was what was happening. And that's exactly what happened. It was challenged by somebody else who thought it was unreasonable and thought their child's right to eat peanut butter was more important than the other child's right to go to school and come home alive. The court said it was reasonable in that case to do a completely peanut-free building, because the medical evidence established that the child's allergy was severe and life-threatening. Now, you're not going to have a severe and life-threatening allergy in every situation. So you want to have the best advice you can. In this case with Philip, it does sound pretty severe. He needs an EpiPen, he can't breathe, get your best evidence. We're also told by the USDA guidance on food allergies that we are required to accommodate this. So we have another law besides 504 that requires us to accommodate this. So seafood-free lunchroom might be the answer. What about having Philip eat alone? I'm hoping no one guessed that because it's not his LRE, right? The LRE requirement is is part of the requirement, but it also appears in the USDA lunch program guidance. So we've got to consider LRE. Oh yes, somebody just said they had this problem with popcorn. Yeah, and popcorn, we all know popcorn kernels they fly all through the air. Someone asked if all food allergies should be addressed in a 504. Do they have to be severe and life-threatening? How would that work with a student on an IEP? No, I don't know that I necessarily answered that. I think what we're saying is that if you need to look to your policy. There are times perhaps when, when a health plan is appropriate, but it's going to depend on the severity of the situation. You should probably evaluate to try to find out what you need. So 504, if the student's already on an IEP, it can go on the IEP. So it just depends, but it's an individualized decision. So on the 504 though, there should be, for Philip, there should be procedures in place about who's going to be wiping down the cafeteria, right? What staff role is going to be responsible for that, not what staff person, because that could change, but what classification of employee is going to be doing that. There should be training of the staff to respond in the event of an exposure. There should be, how you're going to handle notification to the parents. So there are quite a bit of details that can go in this 504 plan. What about offering an alternative food option on the next slide? Let's say that, based on your data, it doesn't have to be seafood free and you're instead going to offer an alternative food option. Should you make him pack his lunch on Fish Friday? Or I think we have a special guest. Oh, we have two special guests coming in to say hello. Come in. Look who's here. Melissa Bondi and Laura Anthony coming to say hello. We're talking about Fishy Philip.
Oh, we hope that you have a good time with Fishy Philip.
Bless you guys.
Oh. I'll see you in February. I will see you in January, I think. All right.
Sounds about right. All right.
All right. See y'all. Have fun.
See you all, ladies. Almost got Josh. All right. Well, we got a little surprise guest. That's fun. Okay, as I said, we're having a festive day here at Bricker because our holiday party is this afternoon. So I think everybody's in a happy and festive mood. All right. So if we do not make it seafood free, is it appropriate to make Philip pack his lunch on Fridays? The USDA lunch program requires that you accommodate and that you make substitutions for a student with allergies if they have medical evidence. So if it's not supported by medical statement, by medical documentation, you have the option of making a substitution, but not the obligation. But if you have medical evidence, then you are obligated to offer an alternative. So we are, it's already 11:13, so I'm going to zip through other steps to respond to mom's concerns. What about his school-related anxiety? Should we be considering IDEA eligibility? Maybe. Is there harassment and bullying? What about the kid waving the fish stick in his face? Should we conduct an investigation into the fish stick waving incident? I would absolutely want to do that. There may be additional suspected disability area here. So harassment and bullying concerns. This kid has an allergy. Kids are waving fish sticks in his face. That's not nice. Now he's not coming to school as a result. So the conduct is interfering with his access to your program. So you should be taking the next steps. All right, let's quickly move on to Wendy. So again, this is so much easier in person when we can do a show of hands, but how many of you are going to say, no way, Wendy's disabled because she's not exhibiting any adverse impact on her education? Well, it sounds like she may be substantially limited in her major activity of breathing. She has a potential chemical insensitivity. So you could have mom complete an inhaler form that the school nurse talked about. You can request consent to do an evaluation and see if she qualifies as an individual with a disability under 504. You can request consent to talk to Wendy's healthcare provider, or you can do all of these things. So anytime an attorney gives you a list and the last answer is all of the above, it's probably all of the above. So spoiler, it's all of the above. So you should do all of those things. So recognize that having a completed inhaler authorization form on file may not sufficiently address all of Wendy's issues. That may address, the practical issue presented so that mom doesn't have to come to school to administer the inhaler, but it will not eliminate the need for an evaluation and possible development of a 504 plan. And then like Philip, you're going to want to convene the meeting, this group of people knowledgeable about the student and the data and the options, provide the parent with a copy of the procedural safeguards and request permission to conduct an evaluation. In addition to asthma, Wendy may have multiple chemical sensitivity issue. You will need more information on her from her medical providers about the existence and the nature and the extent of her disability, as well as identifying any recommendations that her medical providers can help you with. All right, Wendy's evaluation may involve consideration of medical information as to the triggers of this allergy. It sounds like she may have multiple chemical sensitivities. Mom mentioned cleaning products, and mom also mentioned the Katy Perry perfume that is apparently all the rage in her 4th grade classroom. So medical information is going to be important so that you can determine, what environmental irritants are the triggers. In what situations is she likely to be exposed? What kind of exposure causes the problem? Is it skin contact? Is it breathing? Sounds like it's probably, airborne. How long must the exposure be before the problems, start to arise? What happens if the student is exposed to the irritant? What is going to happen? So the results of the evaluation are going to provide that kind of information that you need so that you can determine what accommodations are appropriate for Wendy. It's really important to consult with the healthcare provider if you can. Any information gathered directly from the healthcare provider instead of filtering like a game of telephone to the mom. You might have the healthcare provider documenting it, and then the nurse or somebody else who works in the office reading the doctor's documentation over the phone to mom, and then mom conveying it to you, and you get in this game of telephone, and it's always better if you can talk to them. Sometimes parents, because parents are cautious, they understandably may perceive a health risk to be more serious than it really is. So it is really helpful to have that one-on-one communication. All right, so in our last few minutes, let's talk about Gloria. I'm telling you, Gloria really wanted that cookie, and I love cookies. I can't say that I blame her. But so do you suspect she is disabled? Yes. So we need a 504 evaluation. Yes, we suspect. So she needs an IDEA evaluation, or no, not disabled. So this is the student who's on a gluten-free diet because it helps her concentrate. So she doesn't appear to have celiac. She doesn't appear to have a food allergy. This is a diet she's undertaking because the internet said it would help her think. But let's look at what the facts are here. What have her teachers observed? In our fact pattern, it says that the teachers have told mom she's having trouble organizing tasks. She's having trouble completing assignments. She's having trouble paying attention. She's, having trouble focusing, all of those things that sound a lot like what what OCR was describing in the Dear Colleague letter about being on the lookout for students with signs of ADHD. So mom told you that the gluten-free diet is voluntary. I don't think the gluten-free need is a disabling condition, because she's not on a gluten-free diet because she has a substantial limitation on a major bodily function. That's not what's happening here. But I think we need to know more about this ADHD. So we've got a child find issue. You have now evidence both from teachers and from mom that Gloria may have a disabling condition, possibly ADHD. And so you need to evaluate for that instead. So how you evaluate under 504 IDEA, that is a local decision, but you need to do an evaluation under one track or the other to determine whether or not she qualifies for services. So what about a food substitution plan in the cafeteria? On the next slide, do you have to include a food substitution plan to have this gluten-free diet? Would you include that or would you not include it? So if you have medical information, medical documentation that she requires a gluten-free diet, you are required under the USDA guidance to provide a substitute diet for Gloria. But in this case, we don't have that. We have mom saying, I don't want her to have gluten because I think it makes her less likely to concentrate. So in this case, it's optional. You do not have to. So you can offer a gluten-free diet. A lot of schools have gluten-free options available anyway, because there are so many students on a gluten-free diet. So it probably wouldn't be very difficult. I'd want to be talking about the behavior as well. I mean, what is the school supposed to do in terms of Gloria, who's not a young child, she's a 7th grader, who was offered the gluten-free treat and took the cookie anyway. So those are discussions that need to be held with the parent. So I think that brings us to the end of our materials. And in my haste to try to get through those last few examples, we finished a few minutes early, so you might get a few minutes back. I'm happy to stick around. I appreciate everybody being here today. And if you have questions, I can stick around a little while longer. Or if I have satisfied all of your quest for knowledge about 504, then you can have a few extra minutes of your day back. But thank you, as always, for having Bricker and Eckler to come and present to this group. And if there's anything that we can do to be of assistance, you've got our contact information.
All right. Thank you, Katie, for your time and help today to help better understand 504s. I can certainly say we're getting a lot more requests this year for professional learning on 504s. So while you helped everybody out in the field, you also, I think, definitely helped us better understand things to better, serve our district. So from an SST perspective, I do appreciate that. Again, sorry about the confusion earlier with the materials. I'm not sure where it went wrong or what happened. I'll kind of wear that one. But typically we don't have, I can assure you we don't have those issues. So I apologize for that, but we will see you again next month for the next installment. Let me look up the date here for everybody. The date is January 13th, and that is on discipline and expedited hearings. If you have any questions, like Katie said, you can definitely contact her, contact us at the state support team, and we will do our best to assist you. If the link for the next session is the same as today, so if you have trouble getting that email or finding it, just refer to today's link as well. We wish you guys all happy holidays, Merry Christmas, Happy New Year, whatever it is that you celebrate, choose to celebrate. Wishing you all the best, and we will see you in the new year for the next installment of our ESELA series. Hope you all have a good weekend.
Sounds great. Thank you, everybody. Bye-bye.